of Texas versus Maria Antoinette Neely. We're going to have parties announced for the record for the state.
Jason Garahan, Your Honor.
Defense.
Meredith Chacon for Miss Neely, Your Honor.
And are you Miss Neely?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor, and I have signed the discovery acknowledgement. And before we begin, let me put one short thing on the record with my client, if that's
All right. So the court will find that the state is in compliance with discovery and you may put on the record what you wish.
Miss Neely, you had originally filed a motion to have a different attorney appointed back in November. Are you asking the court to disregard that and have me continue?
Right off the bat, we see a crucial decision. Miss Neely chooses to stick with her original attorney. That may seem small, but in legal terms, that trust can shape the entire plea process. Would you have done the same? Drop a comment below.
He was your attorney today. Yes. And are you satisfied with my representation? Yes.
Oh, thank you. All right, Miss Neely, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Ms. Neely, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review?
Let's break this down. Manslaughter as a second-degree felony holds up to 20 years. But with a prior felony, that's bumped to first degree. Potentially life. That's a massive leap. And the court made sure she fully understood the weight of that risk.
Do that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
And did you understand what you're charged with is manslaughter as a second degree felony? The range of punishment is anywhere from 2 to 20 years in prison with a possible fine up to $10,000.
Yes, ma'am.
And the repeater, Your Honor, we're proceeding with that.
All right.
Okay.
And so with the repeater, if it's proven, then that makes it a first degree felony. The range of punishment for that.
Notice how the judge repeatedly confirms Miss Neely's understanding of her rights. That's to ensure no one can claim coercion later. These aren't just formalities. They protect everyone involved, including the state.
That is anywhere from 5 to 99 years or life with a possible fine up to $10,000. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and rights to remain silent? Did you understand by entering this plea you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Neely, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, you agree that you've been previously convicted of a felony for purposes of enhancement. Punishments be assessed at 8 years in the prison. There are no applications, and the state will take in consideration 2022 CR 10259. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it, and did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any.
There it is. She pleads true to being a repeat offender. That plea just sealed her sentence enhancement. No trial, no live witnesses. Just stipulations and paperwork. Efficient. Maybe. But justice often walks a fine line between speed and scrutiny.
Evidence?
Yes, State Exhibit number 1 with all of its attachments, Your Honor.
And I've gone over that with my client. We have no objection, Your Honor.
Ms. Neely, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments. To the repeat offender enhancement allegation, how do you plead? True or not true?
Here's a legal twist. The judge orders the state sentence to run concurrently with her federal one. But it's not guaranteed. Federal authorities can still decide to stack them. It's a legal Hail Mary, one that could cost her years if denied.
And the court will review State's Exhibits 1 and attachments. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and also based upon State's Exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your
Anything you wish to say on behalf of your client?
Your Honor, my client's taken responsibility. She also has a federal case that she has to take care of. And when she finishes her sentence on this case, she'll be going there. So we'd ask for credit for time served.
All right. And is the felony case, I'm sorry, is the federal case still pending?
No, she was on supervision, so it's going to be revoked, I believe.
All right. I mean, I could ask that this run concurrent with that.
If there's a way to make that happen, that would be excellent. We would ask for that.
I can tell you, because I guess technically you haven't been revoked on the federal case, even though I say run concurrently, it's really up to them whether they will do it or not. Do you know what the case number is?
No, we don't know.
All right. If the court is,
It's like in different cases.
all right, the court is given the case number.
That last speech, devastating. The judge warns her. Asterisk, don't be the prison grandma. It's not just a sentence. It's a life-altering moment. Do you think this kind of tough love helps people turn their lives around? Let's talk in the comments.
The court, of course, will add that and have it added into the judgment. But for now, the court is just ordering that it run concurrent with the federal case. All right. Is there anything else from either side with regards to sentencing?
On the state, Your Honor.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. What are you planning on doing with the rest of your life? That's something that you need to be thinking about. Unless you want to be the person who, when somebody comes to some institution, says, how does this place work? And they say, oh, you need to speak to the oldest person here. And they say, who is that? They're like, oh, we call her Grandma Antoinette. Or either with you, they may say, we call her Queen Antoinette because of your middle name. And then you find out you're the oldest person at the prison. So you had better start making changes, because it's not going to go well if you don't. You understand? All right. Good luck to you. Thank you, Mr. Thomas.